Hello. This tape is about legal issues in student athletic programs managing risks, specifically about Title IX and sexual harassment. My name is Janis Doleschal. I was the Commissioner of Sports and Athletics for the Milwaukee Public Schools for 28 years. Upon retiring from the Milwaukee Public Schools, I started a business called Start Playing Safe and went around to high schools to do risk assessments of their athletic programs, and on occasion was contracted to write a parent-athlete handbook or coach's procedure manual. What we're going to talk about today mainly is Title IX. There will be a short section at the end about sexual harassment, and this is not a comprehensive Title IX seminar videotape. This is to give you as much information so that at least on a basic level, you will be able to assess whether your program is in compliance with Title IX. Title IX was established in 1972 and stated that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. These were education amendments. It didn't deal basically with athletics. It was dealing with education, and athletics was only one small part of it. It is also known as Public Law 92-318 or 20 U.S.C. paragraph 1681 to 1987. The Office of Civil Rights is responsible for determining whether an entity is in compliance or not. After Title IX was enacted, most states enacted similar legislation. In the state of Wisconsin, it's known as Public Law 9. I'm not going to bore you by reading through it, but I will draw your attention. Public school, curricular, extracurricular, recreational, or other program or activity that is not restricted to athletics. And you cannot discriminate based on sex, race, religion, national origin, ancestry, creed, pregnancy, marital or parental status, sexual orientation, or physical, mental, emotional, or learning disability. So, a word about special education and athletics. Since this appears to be a hot button issue, especially within the last couple of years, there is a principle called reasonable accommodation. And parents will throw reasonable accommodation in the face of a school official, athletic director, or a coach. The bottom line with reasonable accommodation is if any accommodation creates a fundamental alteration to the sport or requires a substantial monetary outlay, it does not have to be implemented. Equal opportunity does not mean that every student in the school is automatically eligible and is guaranteed a spot on an interscholastic athletic team. Just because a student is in a qualified class, which is one of those classes that I read about in Public Law 9, and classes also which are referred to in federal legislation, it doesn't mean that the student must be allowed to participate in an activity, especially if the activity requires a tryout, requires a certain level of skill or ability, has certain other eligibility requirements, so long as the tryout, the determination of skill or ability, and the selection process is not discriminatorily applied. Everybody has the right to try out. Everybody gets the same tryout. Everybody's assessed the same during the tryout. So if a parent comes and the accommodation that that parent is requesting creates a fundamental alteration to the sport or requires a substantial monetary outlay, the school does not have to do it. Now, in the past, reasonable accommodation has been made for people, students who are blind, students who are hard of hearing, students who have some portion of a limb or a limb missing. But each case should be determined on its individual merits. School districts must take steps to provide access to participation in extracurricular and interscholastic activities at some level, especially for students with disabilities. This is most easily accomplished in most schools with running a Special Olympics program. But there are so many individual cases that I'm suggesting is that if you have specific questions within your school district, refer to a letter issued by the U.S. Department of Education Office for Civil Rights that was dated January 13, 2013, and it refers to compliance with respect to Section 504 students, and it was sent to all school districts in the nation. There's also an August 2011 Department of Education publication stating creating equal opportunities for children and youth with disabilities to participate in physical education and extracurricular activities. The bottom line is the school district has to take steps to provide access to some level of participation for students with disabilities in some type of extracurricular or some type of interscholastic activity at whatever level. So when Title IX was instituted in 1972, it specified the program areas that would be checked to determine whether a school was in compliance with Title IX. They are the provision and maintenance of equipment and supplies, schedule of games and practice times, travel and per diem allowances, opportunity to receive academic tutoring and assignment and compensation of tutors, which holds true more on the college and university level than the high school level. But if there is tutoring offered on the high school level, it has to be available to female athletes as well as male athletes. The provision of locker rooms and practice and competitive facilities has to be equitable between males and females. Provision of medical and training facilities and services refers on a high school level to an athletic training room and athletic trainers or other types of medical services. Provision of housing, dining facilities, and services holds true more for the more for the college level than the high school level. However, if there is a boarding school, then it would refer to housing and dining facilities and services. Publicity. A word about this. Publicity is not always at the control of the school, but the information being sent out and requested publicity from local newspapers or local TV and radio stations is controlled by the school. The information given is controlled by the school. And if you feel, as an athletic director, that the publicity that you are receiving leans heavily towards male athletes and does not cover the female athletes, then at the very least you should sit down with local media and discuss the issue. The provision of support services, that means pep bands and cheerleaders. The recruitment of student athletes holds true more on the college level, but on the high school level, the recruiting of students to come out for interscholastic athletics cannot all be focused on male athletes and nothing focused on female athletes. There are some non-discriminatory exceptions. They talk about the unique nature of the particular sport. And in most cases, what this is referring to is situations such as a situation that would be existing on a university or college level that requires different types of recruitment for some sports. Special circumstances of a temporary nature, the facility is down and you have to use another facility, or you're in the process of building a facility so that you'll be in compliance with Title IX. A non-discriminatory exception, need for greater funding for crowd control at more popular athletic events. You might spend inordinately more money providing crowd control at a football game or a large basketball tournament than you will for a volleyball match that occurs at the end of the day. But that they do allow, Title IX does allow for non-discriminatory exceptions. Differences that have not yet been remedied, but that the institution is voluntarily working to correct. So if a community member, for example, comes to you as an athletic director and says, I don't feel that your basketball schedule is equitable, or I don't feel that the practice facilities and the transportation is equitable with respect to ice hockey programs for the boys and the girls, and you are working to correct it. If Title IX, if they perceive that a Title IX violation has occurred and OCR comes in, they will take that into consideration. Sport distinctions. These are original sport distinctions in the original legislation from 1972. They made a distinction between non-contact sports and contact sports. And they listed contact sports as boxing, wrestling, rugby, ice hockey, football, basketball. However, what has happened since 1972 is some courts have said, I don't care what Title IX says, I am going to do something different. So some have labeled soccer and baseball, and I will talk about the exception in the state of Wisconsin under District 7. The other sport distinction is sports in which the purpose or major activity involves bodily contact will also be considered a contact sport. Now, in the following slides, the duties correspond to the other presentation that is available to you under legal issues. It's available from the WIAA on the 14 duties of care. So each title in this presentation will briefly list the duty of care, and then the bullet points under it will refer specifically to items that an athletic administrator or a coach would need to address under Title IX. First one, the duty to plan. Under this is a duty to inform parents, athletes, and coaches regarding all rules, ensuring that all sports will follow the same school rules. So the basic rules that are prevalent in a school's interscholastic athletic program must be rules that are there for both male and female athletes. You cannot make a distinction in eligibility rules or any other basic rules within the athletic program. The school needs to provide the same support services, especially where cheerleaders and pep bands are used. This comes up specifically during the basketball season because the girls' basketball program doesn't have pep bands or cheerleaders on an equitable basis when compared to the boys' basketball program. That's probably going to be the area where an athletic director will need to address possible violations of Title IX in planning which games will have coverage of pep bands and cheerleaders. Schedules of practice times and games should be planned so that all sports are treated fairly. Within sports that are both boys and girls, such as basketball, the schedules of the practice times and the games should be equitable so that both are treated fairly. The same plans should be used when publicity is being disseminated or requested. And there should be a schedule planned out by the athletic director or planned out by the coaches and approved by the athletic director for the use of the training room, the athletic training room, and the weight room, since those are the two areas where violations of Title IX are most liable to occur. Second duty is the duty to supervise. With respect to Title IX, the need for supervision in a sport needs to be assessed on a sport-by-sport basis, not based on a male-female gender basis. So if you're talking about supervision, look at the particular entity of that game and then determine whether you need a specific level of supervision. Utilize the same criteria for supervision when assigning opposite sex coaches. And we talked about opposite gender coaches and how to do locker room supervision. But when you're using criteria to assign coaches, you have to use the same number criteria or whatever formula you use at your school for the assignment of coaches needs to be the same for the males and the females, taking into consideration the needs of the particular sport. For example, if basketball for boys, based on the participation requested by students in the school, only fills 4 teams and the girls only fill 2 teams, then the criteria for the assignment of coaches and for supervision can take that into consideration, because the school has done the other portion of their Title IX responsibility of doing a survey to assess participation needs in the school or requests by students in the school, and Title IX requires that every 3 years. Duty 3, which was determining the athlete readiness for practice or competition. Where this comes into play for Title IX is that there cannot be a value judgment or a personal bias that determines whether girls can go out for certain boy sports. On top of that, in the Seventh Circuit, which includes Wisconsin, there was a case called Leffel v. the WIAA. And the judge in this case, as I mentioned earlier, judges are prone to do on occasion, said, I don't care what the distinction is in the original legislation between contact and non-contact sports. And he gave schools, and this applies to every high school in the state of Wisconsin. You have 3 choices. If the girls want a sport, you can cancel the boys' sport, so you don't have to run the girls' sport. You can offer separate teams for boys and girls, which is what most schools do. Or if they cannot sustain a separate team, they allow girls to go out for the boys' team. But you cannot use the last one as an excuse not to run a girls' team. If there are not enough girls to field a team, then the girls can go out for the boys' team. But if there are enough girls to field a team, then that cannot be used as an excuse to say, well, the girls can go out for the boys' teams because we don't want to run a girls' team. If you have enough girls to sustain a girls' team, then the girls must have a team. That's basically what the Seventh Circuit is saying. Cancel the boys' sport, offer separate teams for boys and girls, and if there are not enough girls or enough interest in the school for separate teams for boys and girls, then the girls should be allowed to go out for the boys' team. And there cannot be a value judgment or personal bias that says, I don't want girls wrestling, or I don't want girls playing football. This is a law. It needs to be followed. Now, how does Title IX play into the duty to maintain safe playing conditions? The facilities for comparable boys and girls sports cannot be grossly disparate in condition. Now, if you read a publication put out jointly by the DPI and the WIAA, they talk about baseball and softball not being comparable sports. However, that can't be used as an excuse to let the softball diamond go to wreck and ruin while the boys' baseball diamond has a dugout, lights, and brand new fencing, and the facility is maintained on a regular basis by the maintenance staff, while the soccer field has no dugout, has deplorable conditions on the infield and the outfield, has no fence, and has to be maintained by the coaches. The access to training facilities, such as the weight rooms, cannot be geared only to the boys' sports. There has to be equitable access to the weight room for both the boys and the girls who are out for interscholastic athletics. Safety precautions must be taken for practices of all sports teams. A school cannot assign an athletic trainer only to the boys' practices. If you're going to assign an athletic trainer to boys' practices, then there's got to be some equitable split that also assigns an athletic trainer to girls' practices. The same holds true for games. If you're going to assign an athletic trainer to boys' basketball, then you had better be assigning an athletic trainer to girls' basketball. Duty 5 is the duty to provide proper equipment. Title IX plays into this because the school must provide the gender-specific equipment that is necessary and is required by the rules. A school cannot spend all of its money on safety equipment for boys wrestling and boys football and then not provide the gender-specific equipment that's necessary for girls softball or girls ice hockey. The school must provide the safety equipment. That comes under the duty to provide proper equipment, but it is also Title IX requirement that you cannot provide all of the goodies for the boys' team and nothing for the girls' team. Schools should utilize the uniform rotation plan for the provision of new uniforms and major pieces of equipment. The only exception to this would be if students purchase their own uniform and are allowed to keep it at the end of the season. If the school, in conjunction with the coaches and the athletic administrator and the principal, decide that within a particular sport, the students may purchase a uniform or parts for a uniform and will keep those parts of the uniform at the end of the season, then you've met the requirement of Title IX. But if you have girls and boys basketball uniforms, you cannot purchase boys basketball uniforms every year and girls basketball uniforms every 5 years. It has to be equitable between the same sport, opposite genders. If monies are donated for sports, the use of those monies cannot violate Title IX, and football is not exempt. If somebody wants to donate $40,000 for football uniforms, which are a necessary requirement for the sport, then somehow you're going to have to find $40,000 on the part of the school to provide other necessary requirements of the sport. And this is a major issue when we're talking about booster clubs. So what I'm suggesting is that you use a general booster club plan as opposed to a sports-specific booster club plan. That you have a general booster club, that the athletic director is the liaison to the booster club, that there is a procedure established between the booster club and the athletic department of the school that deals with wishes or needs of the program that are being communicated to the booster club, and that when the booster club donates money to the school, the use of those monies is determined by the school, not by the booster club. Or if the school says we need money for XYZ, then when that money is given to the school, the booster club should say, this is per your request for monies that you stated you needed for XYZ. If the booster club is going to improve facilities, the school needs to be sensitive to the fact that a disparity cannot be created by virtue of the money that's being donated for facilities. And the biggest issues in this state, of which I am aware, usually occur between baseball and softball fields. The sixth duty was the duty to instruct properly. When coaches are assigned, the same formula must be used for all sports to determine the number of coaches. For example, if in basketball you say, we're going to have a coach for every 15 participants, and we'll run the sport on a level for every 15 participants, and we're only going to run 4 levels. So for basketball, you run 4 levels. But when the girls come out for basketball, for girls basketball, you only end up with 30 participants as opposed to the 60 participants for the boys. Then the boys get 4 sports, the girls get 2 sports, boys get 4 coaches, the girls get 2 coaches, because you've used the same formula. Whatever the formula is that you're using has to be used for all sports to determine the number of coaches. It can't be different between boys' sports and girls' sports. The assumption cannot be made that females do not need as much or do not need the same quality of instruction. The coaches' pay for comparable sports must be equitable and determined using the same formulas. Head coaches and assistant coaches should be used, formula should be used in a comparable way. So if a head coach for basketball, for example, for boys, gets $5,000 for a season, then the head coach for girls basketball should get $5,000 for the season. If the assistants get $3,500, then that should be the same for the boys and the girls. The school should determine a reasonable time criteria for practices, and that should have a no less than clause. For example, all sports, in all sports, practices on a daily basis must be no less than 90 minutes, no less than 2 hours, whatever the school feels is necessary. And that's what the reasonable time criteria requirement is. And then again, all athletes must have access to all coaching tools, batting cages, pitching machines, spotting belts, whatever. Duty 7 was the duty to match athletes. I will tell you this, that no cases have surfaced yet regarding girls on boys' teams with respect to this duty. There have been cases reported when boys have refused to compete against girls, most notably in wrestling. And that has to be handled at the school level because it's a federal law. And it's really a federal law in District 7 because the original Title IX distinction between contact and non-contact sports does not exist because of Leffel v. WIAA, which I mentioned earlier. So the other situation that has come up is boys want to be on girls' teams. It's been addressed over and over across this nation in suits leveled by boys who want to be on girls' teams, and they've been thrown out. At this point, the girls' programs are still being viewed as the prior discriminated against class. Sooner or later, that distinction is going to be thrown out. And when that distinction is thrown out, some court somewhere is going to allow boys to compete on a girls' team. Duty 8 is a duty to provide proper physical conditioning with respect to Title IX. The facilities and equipment utilized by teams of both genders must be equitably scheduled and available. Specialized training tools within the same sport cannot be restricted to the boys' program, but a disparity could exist between what the girls have and the boys don't. Did you hear that one? A disparity could exist between what the girls have and the boys don't. If it relates directly to Title IX, because the girls are going to be using the catch-up clause and saying we have to do this in order to catch up on our skill level. But in most cases, let's take pitching machines. The girls' softball team and the boys' baseball team are going to have a pitching machine. And the athletic training facilities and trainers should be equitable and available to all sports. Sometimes you have different injury levels and you've got more girls going than boys or more boys going than girls. That's not what it refers to. What it's saying is that the athletic training facility and the athletic trainers must be equitably available to all sports. So when a schedule is placed, that schedule for the athletic trainer in the athletic training room cannot be restricted to boys or girls unless they give equitable time to both. Duty to warn. Title IX, informed consent. All athletes sign the informed consent statement. Cannot make a distinction between male and female with the initial informed consent statement. If, however, a school is concerned regarding the possible health ramifications of any student playing, the school can request a medical clearance from the student's physician. Sometimes this is because of pregnancy. Sometimes it could be a prior health condition, like a kidney transplant. Sometimes it could be a suspected concussion. But the bottom line is, if you feel that there's a medical condition that will restrict the student from being able to safely participate in practices and games or in competition, then the school can request a medical clearance from the physician. If you have girls on boys' teams, it's the same tryout criteria. Equitable stance from the school. If a girl's going to go out for a boys' sport, then the girl goes through the same tryouts. You cannot adjust the tryouts. Duty 10 is the duty to provide medical insurance. Basically, under this would come the provision of medical services must be equitable. If you're going to require students to have insurance, you have to require all students to have insurance that are coming out for athletics. If you're going to provide viable access alternatives for insurance to those who do not have it, it has to be provided to all athletes, not just the male athletes. Again, the utilization of athletic trainers must be equitable, and the provision of training and medical services must be equitable between genders. I'm sure you figured out by now that some of these overlap. Duties 11 and 12 are the duty to have an emergency response plan and the duty to provide emergency care. While all sports should have an emergency response plan, the provision of the same availability to emergency treatment and care cannot be different, simply because there is an emergency response plan and you claim that it's covered in your emergency response plan, that the boys' ice hockey team will have an athletic trainer present at all practices and games, and the girls' ice hockey team will only have an athletic trainer present for games, and it's incumbent upon the coach to provide emergency care for ice hockey. For the girls, you cannot have that type of disparity. Athletic trainers must be accessible and available to all sports when they have their office hours in the school, and when you assign athletic trainers to events, they must be assigned in an equitable fashion. The same sports medicine facilities must be available to all sports. If you are contracting with a sports medicine facility in your community to provide athletic training and emergency care at athletic events, then that sports medicine facility and its athletic trainers must be available to all sports and assigned on an equitable basis. The scheduling of trainers cannot favor one gender over another. Duty 13 is to provide safe transportation. The transportation to practice facilities and games must utilize the same types of transportation. When I was going out and doing risk assessments, a portion of that risk assessment was determining whether a school was in compliance with Title IX. And it was not unusual to find a boys' team traveling on a coach and the girls' team traveling on a school bus to the same types of activities, because the booster club, sports specific or general booster club, was providing funds for the boys team to transport on coaches and the girls team not to be transported on coaches, but to be transported on school buses. Now, there is a rule regarding transportation that a school could conceivably have that says outside a 75-mile or 100-mile or 50-mile, whatever radius, coaches will be provided for transportation to and from athletic events. In that case, the utilization of different types of transportation can be sustained because the policy is applied to both boys and girls sports. But if you're going to set up coach transportation on a regular basis for the boys and school bus for the girls, your school's not in compliance. If school-owned vehicles are available, the use should be comparable between the same sports. For example, tennis or golf, especially if they're in the same season. Now, in most cases, WIAA has individual sports at opposite seasons, but if you are in a school that, for whatever reason, has individual sports in the same season, the use should be comparable between the same sports. And what I'm saying is you might have an interscholastic team and you might also have a club sport in a sport like tennis or golf operating at the same time. And if they do, the club sports come under Title IX. Behavior rules on the buses must be enforced equitably among all sports, among the boys and the girls. That just is common sense. Title IX, Duty 14, the duty to select, train, and supervise coaches. You cannot neglect the training and supervision of coaches in same sport, opposite genders. The way to get around all of this is to have specific job qualifications, specific job application, have a specific job description, have the same evaluation criteria and pay scale, have the same type of interview process for coaches for the boys and the girls program. And then you will be in compliance with the select, train, and supervise coaches. Another point is if you're going to supervise games, a concentrated effort should be made to supervise events in a particular sport with opposite sexes during the same season. The AD should make it a practice to make it to both boys and girls events. Additional Title IX provisions that would not come under the specific duties of care: publicity within the school and publicity shared with the public must be generated and produced using the same processes. For example, if Frito-Lay's wants to take a picture of the boys, well, let's use football, the boys' football team, and that's going to be on a poster with the schedule, and that's going to be disseminated throughout the community and throughout the school, then Frito-Lay cannot say to you, and you cannot accept if they say, I'm only going to do boys football. They have to do equitable publicity. So somehow you're going to have to sit down with Frito-Lay and come up with some criteria for which teams are going to have their pictures on schedules. The recruitment of student athletes cannot be restricted to boys' sports. Now, when I'm talking about recruitment, I'm not talking about illegal recruitment from another school. I'm talking about recruitment within the same school. And the recruitment within the same school cannot be restricted to the boys' sports. If you're going to do PA announcements for boys' sports, you have to do them for the girls' sports. If you're going to put posters up for the boys' sports, you're going to do it for the girls' sports. If you're going to have a special night or a special activity to recruit students as freshmen, has to be open to all students, boys and girls. Booster clubs are considered sports services and as such must provide equitable support. Many booster clubs don't understand this. Many booster clubs don't understand that they would come under Title IX, and many booster clubs do not understand that any support they are providing to the school must be provided on an equitable basis. And who determines the equitable basis? The athletic director. So you're going to have to be very, very careful working with the booster clubs. Guidance counselors or anyone else in the school that does this must provide equal access to scholarship applications. You can't just take the boys' teams and say, well, the boys have more of an opportunity to play in professional sports, so we have to help them get more scholarships on the college level. No. If there are scholarships available for male athletes and female athletes, your guidance counselors have to provide equal access to those applications. And by the same token, equal access to work programs or grants that are available to athletes, all athletes. Your best Wisconsin resource for Title IX is the Pupil Non-Discrimination Guidelines for Athletics. It's available on the DPI website, as cited here. It was put together by the WIAA and the Department of Public Instruction, and is still one of the most comprehensive guidelines to determine whether your programs, all of your programs, are in compliance with Title IX, because it does not talk just about generally athletics. It will talk about specific athletic programs, specific support services. I want to talk a little bit about sexual harassment, since sexual harassment is now, in many cases, especially on the college and university level, coming under Title IX. And many schools, interestingly enough, when they provide Title IX, in quotes, training to their athletes, coaches, and staff, do not address the original issues of Title IX, which would have been the ones we listed earlier in this presentation, dealing with sports. When they're dealing with their athletes, they're concentrating on sexual harassment and sexual assault. So that's why I've included it in this. Your responsibility as a school and as an athletic administrator in conjunction with the school is to respond promptly and effectively to anything that you think might have even a tinge of sexual harassment or sexual assault in it. And if you hear about something like this, you must investigate it even if the parents do not want to file a complaint. It's incumbent upon the school to investigate and take appropriate action. The school must distribute a policy regarding issues of sexual harassment and sexual assault. The school in that policy must state what they are defining as sexual harassment and sexual assault, what the disciplinary action will be, what steps the school will follow in investigating the incident, and the policy must be distributed to all students and parents and guardians. You must have a Title IX coordinator. That's required by the initial Title IX legislation, and it hasn't been changed. Just like the requirement to do an interest survey every 3 years hasn't been changed. But many schools, for whatever reason, and districts, don't have a designated Title IX coordinator, and they're not doing the interest surveys. School must have established procedures and make them known that if a student feels that he or she has been the victim of a sexual harassment or sexual assault, they need to know how to file complaints of sexual harassment or assault or of sex discrimination in the interscholastic athletic program or in the physical education program. But since we're talking about mainly athletic programs, under the athletic director would come if there is a complaint of sex discrimination, then that procedure must be established by the district, step by step, so that the student knows where he or she can go. And that's why the Title IX coordinator is required, because that is a person who has no vested interest in the program, has a vested interest only in helping determine whether there's been a violation or not. The school should consider training all school personnel regarding sexual harassment issues, school policies and procedures regarding sexual assault, sexual harassment in the classroom, out of the classroom, in all of the programs in that school. Also, obviously, encompassing interscholastic athletics. Lee Green, who was an attorney, and I believe it was Ohio, Baker University, put together 10 recommendations to prevent sexual harassment claims. He did this for the NIAAA, but I'm sharing them with you. And even if some of these border on what you might deem comedy, or, well, of course, nobody would do that. Trust me, they do this. These were put together, if you look at my end note here, after Professor Green went through hundreds of school cases that he reviewed involving sexual harassment. So, first one, never use sexually explicit language or tell sexually explicit or off-color jokes in the presence of students. And if students are doing it, then it's incumbent upon the coach to stop it. Coaches should never display sexually explicit pictures or materials on school property or show them to students. Coaches have been known to have pictures in their lockers, and if there is a student standing there and sees the picture, that is now a coach displaying a sexually explicit picture to a student. So, coaches need to know that they can never display sexually explicit pictures or materials on school property or show them to students. Third, coaches should never engage in personal conversations, in person or on the phone. Now, what I'm talking about when I'm saying personal conversations, I'm talking about conversations between a student and a teacher, an athlete, and a coach that refers to possible personal issues between the two. I'm certainly not naive in thinking that students are not going to share personal issues with coaches. That's not what this refers to. What it refers to is personal conversations regarding personal liaisons or the attempt to create a personal liaison between a student and teacher or a coach and athlete. Coaches should not send personal gifts or personal messages to students. Again, this refers to an attempt to create a liaison between the two that goes beyond what it should. There was a coach in the state of Wisconsin who eventually was jailed for sexual assault against students. And that coach, in order to get students to come out for the particular sport, sent jewelry to the girls. That's what I'm saying. You avoid sending personal gifts or messages. That was clearly way outside the bounds of what should be done. Avoid commenting on a student's physical appearance, student's dress, or student's physical attributes. This refers to comments like, gee, you look good when you wear tight jeans. Or, gee, you should wear tight sweaters more often. Or, yeah, those jeans are really nice. I can see everything. Those are the types of comments that should be avoided, or physical attributes. You'd be a better athlete, and this comes under this. You'd be a better athlete if you didn't complain about your period when you're going out for a sport or when you're coming to practice. That is just totally out of line. If a student has issues because of a menstrual period, that should be an individual discussion between the coach and the student, and there should be something placed in writing. But a comment like that made to all of the students at a practice or game is totally out of line. Avoid physical contact or touching of students. I had a diving coach at MPS who is now serving 40 years for sexual assault. At the time that he was a diving coach for MPS, I had a complaint regarding the fact that when the girls were trying to get out of the water, he would stand and block the ladder, so they had to rub against him. They thought they might have seen him in the locker room at one point when he was helping them with dives. His hands were moving up or down where they shouldn't be. And while I was able to get rid of him as a coach based on the students' complaints, the district did not fire him as a coach until there was an outside issue where parents complained about sexual assault. And as a result of that, the police came back to the school district, took the information that I had from my initial investigation, and as a result, he's currently serving 40 years. Students know the difference between physical contact and touching that is used to teach, that is used to move students around, to put them in proper positions for plays, that is used to take them through a movement kinesthetically. They also know when they're being touched inappropriately. And if a student comes and tells an athletic director, I think this is happening, the athletic director needs to investigate it immediately. Coaches should avoid giving students rides home alone or in groups when at the end only one student will remain. Giving students rides home alone puts the coach in a position that a student can level complaints, whether the complaints are legitimate or not. And students riding home in groups when at the end the same student is one student remaining. That also happened in MPS when a coach did this and then assaulted the student. And of course there was sexual intercourse between the coach and the student in the back of the car, and eventually it came forward when the girl began to feel uncomfortable about it, told her parents, and then the coach was confronted with it. Never plan or take unchaperoned trips with students. If it is an overnight trip especially, there should be at least one other adult, whether that's an assistant coach or a parent chaperone or a volunteer chaperone. A coach should never be in the situation of having to take unchaperoned trips with students. Now, I know this happens occasionally if they're taking a varsity team to competition, but generally speaking, coaches should not plan or take unchaperoned trips with students. And the last one is a given. Coaches should never date students. So the responsibilities of an athletic administrator with respect to Title IX: investigate your programs, facilities, and procedures for any possible Title IX violations, including, again, the requirement that every 3 years you do a student interest survey. My suggestion on a student interest survey is you don't just ask, would you go out for the sport if it were offered? You need another question on there that addresses, are you currently out for a sport during the season that this sport would take place? And would you drop the sport you are currently in order to take that sport? That's the only way you can get a legitimate answer. Your responsibility as an athletic director, if you see anything that's a Title IX violation or could be a Title IX violation, is to alert the proper school or district authorities. If they're not sure, they should contact legal counsel. If community advocates perceive of a violation, deal with their concerns as soon as possible. Don't poo-poo them, because they are the ones that can file a Title IX complaint against your school district. And you do not go through a Title IX complaint when the Office of Civil Rights comes in, because they will not investigate only the athletic program. They will investigate the entire school and in some cases the entire district. So you want to deal with their concerns as soon as possible. If you're not sure if they're correct, contact someone who can give you legitimate Title IX explanations, which would be your legal counsel or someone in an attorney's office. If you suspect there's any sexual harassment occurring in your program, investigate it immediately. This includes bullying or initiations that occur by upperclassmen on underclassmen, and it includes sodomy with broomsticks and all sorts of other interesting things that teams have come up with over the years. It cannot be tolerated. Hazing cannot be tolerated because it can also be addressed under Title IX if there's any sexual assault or harassment that occurs as part of it. Finally, be consistent when you are addressing Title IX issues, and be consistent in your disciplinary action or in taking any remedial steps. Thank you. That concludes the video on Title IX and sexual harassment.